the sports sector, given my personal involvement, I have a particular sensitivity to governance matters because governance doesn't matter until it does, and then it really matters when things go wrong. And so what I want to do is just maybe briefly walk through the fundamentals of corporate governance and then make it a bit more specific to not-for-profit sports organizations, and then maybe delve into some of the typical issues we see come up and give some possible solutions or ideas for you to take back to your own local organizations to help out as best as possible. So sport law is Canada's leading advisor to local, provincial, and national sports organizations. We advise a number of NSOs, the national sports organizations, very large number of PSOs across provincial sports organizations across the country, and then the local organizations such as the membership here, and so we see a lot. And the interesting thing is we see a lot, but we see the same thing over and over and over again. And what tends to happen for all of the right reasons is that problems happen for all of the wrong reasons. And what I mean by that is, by definition, you're a part of a not-for-profit organization. Some of the provinces call them societies, others call them not-for-profit corporations. But the fundamental concept here is you're giving back to the community, and you're fundamentally involved in the sport to be a productive member of the community, to make your community better, to facilitate sport, the development of kids into adults, the fruition of adults as citizens, all of the good, touchy-feely, wonderful things about volunteerism or lowly paid employment opportunities in the sector. Nobody's getting rich on not-for-profit sport in the country for the most part. There are some exceptions at the upper levels, but for the most part, people are in this for love of sport and love of community and a sense of service. And what that means is governance tends not to be your highest priority. You're involved for other reasons. You're not getting involved because you love bylaws. You don't sign up to participate in your sport because you love bylaws. You sign up because you love the sport and you want to get people participating, kids participating, your fellow citizens participating. And so the governance stuff tends to get put to the side. And it only gets paid attention to when one of two things happens. A crisis in the organization happens, or there's a conflict between adults. So-and-so's kid didn't get picked, or I wasn't allowed to coach a team. And all of a sudden, people start digging in to the corporate governance materials and start trying to find ways to access power or to embarrass people in positions of power. That's bad enough. When situations go bad, and I'm talking specifically now about safe sports situations, that's when your governance really needs to be in place. There's been a revolution in Canadian sport over the past 2 decades, in large part directly related to a situation I was personally involved in. I'm one of Graham James's victims. Graham James being the hockey coach, Sheldon Kennedy, Theo Fleury, or whatever. I'm one of that group. And the response of the sporting world was so much good. People wanted to try to make sure that something like that could never happen again. What happened was a layering of an incredible amount of bureaucracy into sport. The safe sport policies, the respect in sport checks, the programs, the certifications, all of the good stuff that is properly in place to try to make sure that bad things don't happen. The problem is that volunteers and staff, underpaid staff and volunteers, they now face so much administrivia to deal with. And the governance obligations on your organizations is more highly focused upon, given your legal obligations to dot your I's and cross your T's to make sure that things like that don't happen. Because the first thing that happens when something goes wrong, when there's a problem, people look into, well, who was responsible? Who should have stepped in? Who should have disciplined? Did the membership put in place the proper board of directors? All of those types of things. And that's when you realize that your governance actually does matter, that it is important, and that's when you wish you had paid attention to it and treated it as the serious aspect of your business that it really is. And I refer to it now as a business because In Saskatchewan, you are a not-for-profit corporation. You are a corporate entity, and you are expected to behave as such. And so what does that mean? That means you have to govern yourselves appropriately. In Saskatchewan, there's a Not-for-Profit Corporations Act. That's the rule book with respect to your legal obligations when you establish yourself as a not-for-profit company, a not-for-profit corporation. Fundamental to the establishment of your corporate body, you put in place a set of bylaws. What are bylaws? Bylaws are effectively the corporate rule book that set out the relationship, the contract between the organization and your membership. So at the outset, somebody sat down when your organization was put together and said, okay, who are our members? How are we going to structure our operation? Are we an organization that has a group of clubs that are our members, or are the participants our members? Is there a distinction in the bylaws between participants and members? Are both teams, associations, both of those entities, are they members? Are the participants, the teams, the associations, the conference? You see where this goes. At the fundamental first step, as a legal requirement to put in place your very existence, the existence of your organization, those decisions were made. Now, just because a decision was made when your organization was established doesn't mean that your organization has to continue on the same way. Bylaws can be changed. The membership can come together and say, look, this is how we're set up today, but maybe that's not the most efficient way on a go-forward basis. Membership, can we maybe reconsider this and structure ourselves in a way that would be more efficient in the community? Because what we're here to fundamentally do is serve the community. And that's the second key element about what happens when you establish yourself, when you set up your governance documents. You put in place a purpose. The organization exists to serve a purpose. And normally not-for-profits say they're here to serve the community in whatever field it is, in the sport of soccer, and in define your territory, the region, the city, the community that you're serving, that type of thing. But what that means is your bylaws define who your members are, and your bylaws define the relationship between the corporate entity, which is just something ethereal that exists as a name that's filed with the corporation's office, and the actual essence of who you are and what you do in the community. There's no such thing as a corporation without a member, right? You have to have at least a member, and you've all got numbers of members out there. The bylaws are the rule book, the operations manual, effectively, for the legal contract as to what members can do and are required to do on an ongoing basis to keep the organization afloat and to sustain themselves as members in good standing. Now, what does it mean to say that you're a member in good standing? Well, all members of an organization are required to adhere to whatever rules have been put in place. And that fundamentally usually means you pay an annual fee as a member. You have to conduct yourself in accordance with the expected behavior of the organization. And you have to ensure that at all times you don't deviate from the organization's bylaws. That's the base level of obligation when you become a member of an organization. Now, given what's happening in sport, the obligations have exploded. They've absolutely exploded. I'm sure you're all familiar with codes of conduct, privacy policies, inclusion policies, discipline and complaint procedures and policies. When you click on organizations' websites, you see policies covering virtually anything you can think of. And that may seem like a lot, and oftentimes it is a lot. And again, I always apologize when I speak to groups like this, because all of this paper comes out of the attempt to do good coming out of a very bad situation. My argument to you is, when it seems like it's burdensome and it's overwhelming and all of the paperwork, take a step back and try to remember why all of this is in place, why all of these governance obligations exist. They exist to try to push organizations in the right direction, to ensure that the adults who are involved in sport are there for the right reason and that they're serving the children in the community on the best possible basis going forward, to ensure that the focus is on the participants, the kids, the athletes, however old they may be, and not on the self-interests of the adults involved in running sport. Think of a conflict of interest policy. Why does an organization have a conflict of interest policy? Well, because people could take advantage of an organization and use the organization's needs for personal benefit, kick contracts in a self-interested way to a personal interest or company or a friend's interest or company. That's not why not-for-profit organizations exist. Not-for-profit organizations exist to serve the community. So all of this governance stuff, all of these policies, your bylaws, your codes of conduct, your rules, your procedures, fundamentally, if you can keep in your mind front and center the concept that everything that's written down as a rule is fundamentally there to serve the community, that will reinforce and drive home why you show up every day as a member, as a volunteer, as a participant, as an administrator, as a staff person. You're fundamentally there to serve the community. And when you start seeing things that way, it becomes a very interesting experience, and I would argue rewarding experience. It's not just a job, and it's not just being there. You're being there to do good. And I think everyone involved and spending any time even listening to any of this, remember that as you go forward. You're doing good in your community. And so see the governance documents, the materials and the obligations, the rules, the bylaws, as forces helping you do good, not as stuff getting in the way and needlessly taking up your time, even though it can seem that way. At the end of the day, this is good, not bad. Any questions with respect to that little introduction? That's my sermon from the mount. That's my trying to hit everyone over the head that all of this stuff that seems like it can be pointless is really, it is meaningful and important. Seeing no questions, I will move on. So, in your organization, you have bylaws. Those are the fundamental rules. You have to identify who your members are. Increasingly, we see as best practice, where possible, a distinction between having corporate groups, teams, associations, divisions as members, as opposed to individual participants. That said, when you're talking about your local organizations, as you have here on this call, it makes more sense for the participants to be members of the organizations and not the teams or the age groups or just the coaches or just the adults or whatever. Participant membership is important at the local level for a number of reasons. It allows you to enter into direct contractual and legal rights with respect to the participant so that when they sign up, they become a member of your organization, and you can more clearly exert control and discipline and affirmative obligations to comply with proper behavior and conduct than you otherwise could. And the second reason it's better at the local level is that we don't want to be in a situation where we're just creating layers of bureaucracy to keep individuals from directly being members. When we talk at the PSO and the NSO, the provincial and national level, we tend not to like to have participants as members of organizations because your membership base can become too big where it becomes ungovernable. And you're better served by having clubs, associations, divisions, conferences, or whatever as your members, not the individuals. And you draw a distinction between a member and a participant. Here in the local situation, for your local clubs out there who are themselves members of the Saskatchewan organization, your participants can be members, and that's fine in terms of best corporate practice. You'll often hear that it's not best corporate practice anymore to have participants as members, but at the local level, it's fine. What's important, more so than whether the participant is or isn't a member, is trying to figure out who your voting members are. Just because you're a member of an organization doesn't mean you're a voting member. So think of the local sports organization out there that signs up all of its participants and the participants are members. Well, you have an immediate instant problem if you have kids playing because you do not want kids exercising statutory rights or legal obligations or contracting at a legal level. What you have to do then is build into your governance material a structure whereby if you're under the age of 18, any right, responsibility, or obligation you have as a member or participant to the organization, you have to designate an adult, a parent, or guardian to exercise that right on your behalf, including the right to vote. You do not want 7-year-old kids showing up at your annual meeting voting, right? And I say that with a smile on my face, but there are organizations in the country that actually do that. And it's just silly and it's chaotic and it's a mess. And you can imagine that when the parents get into a fight about who's going to be elected a director or not, it's a gong show. Um, so my guess is that nobody on this call has that situation because it's already been addressed, but I'd like to drive that home. Fundamental good governance is to ensure that no one not of age is ever a voting member or someone with a contractual legal obligation at the fundamental governance level. Absolutely, your participants need to be signed up under your membership documents to your policies, rules, procedures, and codes. And where possible, you have an adult sign their membership form at the same time, just to ensure that no sharp lawyer down the road will say, well, the family didn't sign up for that because you got the signature of a kid and the kid isn't contractually entitled to bind at law. So again, I'm sure that all of your membership documents at the club level have adults signing on behalf of kids and stepping in to represent the kids. And it's always a good idea just to review your membership packages to ensure that that happens. My guess is that when you sign on as a member and you sign on to adhere to the Saskatchewan policies at the same time as your local obligations, that's made clear. And that's an important fundamental tenet. So we've covered the reason that governance exists in the first place. We've established that the bylaws are your rule book. What do you want your rule book to look like? You've identified who your members are, who your members are going to be. You've put in place a membership package when they sign on. Ideally, we like to see that membership does not automatically renew, that every year membership terminates and the membership cycle starts anew in the next year. Why do we do that? Well, because what we've seen in the recent past is that the rules of sport are changing. The whole safe sport regime has come in. Policies are changing virtually on an annual basis as Sport Canada is placing increased obligations on the NSOs, and that filters down to the PSOs, and that filters down to the local organizations. It's just good corporate practice to ensure that there's no perception out there that anyone is entitled to membership. And what that does, requiring annual application, it makes it easier for you as an organization to root out problems when problems need to be dealt with. And it's a delicate topic because we all like to pretend that we deal with only good people, but the reality is that there are difficult people out there. And anyone who runs an organization knows that there are difficult people out there. And sometimes in this modern world with too many lawyers running around, the discipline process can be slow, it can be inefficient, it can be not enough for an organization to do what it must do. The more flexibility that an organization has, the better. So if an organization has at its disposal the ability to impose a condition on a member coming in at the start of a year after a bad experience, that is a wonderful thing to have in place, where a board of directors can get together and decide that if so-and-so is going to become a member next year, the board is going to adopt a policy that, and then fill in the blanks, what will be required on a go-forward basis. Annual membership is an asset to be deployed to your benefit on a go-forward basis to ensure proper conduct. That feeds into another issue. Who should be on your board of directors? Sometimes organizations get lost in figuring out who should be on the board. Most often we're seeing now, especially post-COVID, organizations can't find enough people to serve on the board and to do any heavy lifting at all. And so they're just happy to get a warm body. That's unfortunate because in a not-for-profit, a director is actually a very important person, provided they're focused on the right thing. And let me explain. Boards can be two types. They can be operational or they can be governance. And what we see is that directors sometimes think of themselves as having operational responsibilities when what they really should be doing is focusing on the governance. And what I mean by that is, in the old days, we would list a number of positions open for election. You would, as a member, show up at an AGM and you would see a position. You were voting for the president and you were voting for the treasurer and you were voting for the secretary. Best corporate practice now, we believe, is for all directors to be what's called at-large directors, where the membership simply elects directors. Why do we say that? Well, at the end of the day, directors, whatever their title, all carry the same legal responsibility and fiduciary duties to the organization. There's no difference whether you're the president or whether you're an at-large director or whether you're the treasurer. If something goes wrong with the finances, the treasurer is no more responsible than just somebody elected to a director position without an office. A director is a director is a director, irrespective of what they're called. What we find in not-for-profits is that when somebody runs for president, they run for president and then they think that they're king. And that's a really bad dynamic to have in an organization. No organization should have a king, or queen. No organization should have an emperor or whatever. What ideally happens is you have those offices for responsibility, but once the directors have been elected as a group of directors, the directors after the meeting of the members, the directors themselves get together and they, for a one-year term, appoint or elect amongst themselves if they can't agree who's going to do what. They assign amongst themselves the responsibilities because at the end of the day, the board is collectively responsible for everything being done. And so the thinking is that if the board is collectively responsible for ensuring that everything's done, the board should be determining who goes into what position because ultimately the board is responsible. And you can't have a situation, or you shouldn't have a situation, where the membership has elected an unqualified individual as treasurer who is unable to fulfill the financial duties. The board should have the ability to determine who amongst the board is best able to fill the obligations of the position of treasurer. And that's a bit of a change, right? We're accustomed to voting people into specific office, but that's no longer best practice. And in fact, the Canadian Sport Governance Code, which applies only at the national sports organizational level, but it's slowly filtering its way as best practice throughout the sport world in Canada. That's the way it's structured at the NSO level now. You just elect directors and then the directors go off and do whatever. The next thing we like to focus on when we start thinking about who can be a director, who should be a director of an organization is independence. In this day and age, it's really difficult to find independent directors. And what do I mean by an independent director? I'm not talking about somebody who has nothing to do with the sport or no connection with the sport or who isn't a parent or whatever. But we like to keep people with financial interests in entities related to the sport off of the boards of directors. We don't want the owner of a local indoor soccer facility on the board of a local soccer organization, just because the conflict is there, and whether the director with the conflict steps back or doesn't, the conflict is always there, and there's always that moral pressure that the group would feel having to deal with so and so on an ongoing basis if they didn't sign up to an agreement with that facility and they went somewhere else, or they chose not to use that facility at all. To the greatest extent possible, you want to make sure that a board is independent, that the board doesn't find itself in awkward situations where directors have to step back. Sometimes it's unavoidable, and in local organizations, it's unavoidable. And so what do you do then? You have to aggressively turn your mind to how do you make things as fair as possible to everyone. And when you think about what does it mean to be as fair as possible to everyone, You're thinking about, again, I'm here to serve the community. This organization is here to serve the community. What's in the community's best interests, not what's in so-and-so's best interests. And that's an important and difficult thing to do, especially in smaller groups and associations and communities, when just the nature of community itself means that you're all intertwined in sometimes complicated ways. There's no perfect solution. The issue is to do the best in a difficult circumstance. But to the extent on a board you can be independent, that's absolutely the way to go if you can do it. And if you can't do it, you just have to turn your mind to aggressively managing conflict to ensure best practices. And so what do I mean by best practices? We've identified who our members are. We've identified the rule book and the bylaws. We're fleshing out the bylaws a little bit. We've got the directors and conflicts of interest addressed. We're trying to figure out, how should we operate our organization? What are some of the values that we want to live in our organization? And remember, right now, we're just writing the rules, because it's a very different thing to write a rule and to live a rule. You can take the example of conflicts of interest. You can have the best, most perfect conflict of interest policy ever written, and then the minute it goes live, it gets filed in a drawer, it gets posted on a website. If you don't live that value, no perfect paper is going to get you out of a difficult situation. Your organizations have to live your values. They can't just write the paper that's required and check the box and say, I'm done and all is good. You have to live these values. And so with respect to how do you want the organization to run on a go-forward basis, the best thing an organization can do is always try to pass what I call the Rick Westhead test. Rick Westhead is the TSN reporter who pops up anytime there's an issue or conflict or anything controversial in the Canadian sporting world. And usually it's after the fact, where some coach hasn't been disciplined appropriately and people are smacking their heads when they see the TSN report on the news. How could any organization be so dumb as to have allowed that to happen? That's exactly the standard you should apply to everything that you do in your organization. Always, always, always ask yourself, what would this look like if something went bad after I did this? And that's practicing governance by defense, but that's a very helpful way to model your behavior on a go-forward basis. You come at it first saying, I'm here to serve the community. And then you think, what would it look like if this decision actually stood and something went wrong after this decision was passed? What would it look like if we let so-and-so on the board while we made this decision, or we bought product from so-and-so, that type of thing? What would that look like? What would it look like if we received a complaint about a coach and we didn't immediately take a coach off the field, notwithstanding innocence until proven guilty, and it turned out he had done this or that? You always have to act with a lot of common sense and a little bit of deference to what your gut is telling you is the right thing to do in the circumstance. Because again, no amount of perfect paper and a policy and just blind adherence to anything is going to get you out of a situation where you've done something that doesn't pass the smell test or the commonsensical test. And that's a really difficult concept to accept, especially when it comes to governance of an organization, because what that's saying is, you as a director of an organization you have an affirmative obligation to follow the written policies that you've put in place, because the policies are there for a good reason. But chances are you're going to find yourself in a situation where the paper may lead you in a direction that doesn't really solve the issue in a perfect way. It may leave a door open, or there may be a time delay or whatever. You're going to be put in a position where you have to sense yourself, how should I act here? And so I'm going to say two things. Always trust your gut and get a second, third, and fourth opinion along the way. No one ever looked unreasonable by saying, look, I'm in a difficult situation here. My policy or my governance materials or my bylaws are telling me I have to do this, But I'm really worried that if I do this, that leaves the door open to a very real risk on an ongoing basis at the club. I think we should maybe do something a little bit differently here. What do you think I should do? Push it up the chain. You've got your governing body at your disposal. The organization will help you work through a problem. And that's why governing bodies exist, is to try to help groups, members through difficult situations. And again, no one will ever be upset at you for asking for help in a difficult situation. So it's another fundamental I want you to take away from this. Good governance is only as good as it exists on a day-to-day basis in reality. Absolutely, the paper is good and should be as perfect as possible, but perfect paper is never a substitute for actual good governance in the real world. It's confusing. It's less than perfect. I'm a lawyer telling you I'm not going to always be able to give you the answer, even if I were to draft the perfect policy for you. But that's life, right? That's just the nature of being somebody trying to serve the best interests of the community. Sometimes there's going to be no clear answer or clear direction in terms of how best to proceed. So does anyone have any questions with respect to directors? Does anyone have any problem directors in their organization? One of the things we find that is potentially difficult is some people like to talk more than others, and you're seeing that I love to talk today. It's important for all directors of an organization to understand that they have an obligation, if not to speak, to make sure that things are being done appropriately. Because all board members are equally responsible for decisions when it comes to governance, good governance requires everyone on a board to pay attention and accept responsibility for what's going on. You cannot shield yourself simply by saying, well, I disagreed with that. The board makes a decision, the organization makes a decision, it's on everybody on a go-forward basis. Where can things go wrong for an organization? The biggest potential risks today are safe sport issues and financial impropriety. And so when it comes to good governance at the not-for-profit level, those are the two things we really like to drill down on, to try to make sure that organizations implement proper rules and procedures to ensure, to the best extent possible, that eyes are open, ears are open, and feelers are out there with respect to knowing what's going on in the organization, to try to ferret out as best as possible issues before they fester into real problems. The whole area of safe sport is incredibly concerning, simply because bad things happen and we know that bad people are out there, right? No matter how hard we try to pretend otherwise, and no matter how many safety checks we do, there will be bad people involved in sport for the wrong reasons, and using their position in sport to try to do whatever nefarious acts they want to do, whether it's with respect to safe sport issues and taking advantage of athletes, children, or people who are in vulnerable positions, or whether it's people who are trying to take advantage of lax financial systems and access the money and whatever for their own personal benefit. Those are the two biggest risks that an organization has. You've all seen the abundance of legal process, form, lessons, teaching, ongoing education, ongoing certification, background checks on the safe sport side of things. The one thing I always remind everyone is Graham James would have passed a background check because when he was doing what he was doing to us, he hadn't yet been convicted and he would have come back clean. So absolutely background checks are important, but absolutely background checks are meaningless with respect to identifying someone who hasn't yet been caught at anything, right? And so that's something to always keep in the back of your mind. Just because you have a fulsome screening policy and background check system in place does not mean the people who you have working in your organization are safe. They're not. And this isn't a sports specific issue. This is a society specific issue. There are bad people in all walks of life. And it just happens that we're focused now on sport because we're dealing with sport. But it would be silly to pretend that just because we have background checks in sport that there are no bad people in sport. So eyes open, ears open, and try to stay as connected as possible to your organization with respect to identifying problems. What that means on Safe Sport is boards of directors should have as standing items every time that they meet a review of any issues that are going on with respect to conduct in the organization. And so organizations will often have reports. They'll have coaches come in or technical directors or the heads of this or that, and those individuals will talk about the success of the team. This team went to a tournament. This player got here, and they'll get a feedback of all of the success of what's going on the playing field. What directors need to know, that's wonderful. That's good, and success on the field absolutely important to an organization. But to a director, not important at all. What a director is concerned about is protecting the organization and the community in which the organization operates. The directors should be more concerned about having those people come in and say, we have a potential issue with a coach who's paying too much attention to this athlete, or we have potential issue, it looks like on this team with respect to a group of athletes who may be bullying somebody, or those types of things. All of the issues that are addressed in your code of conduct and in your safe sport policies, that's what the board should be focusing on. That's what the board's legal obligations and requirements are directed fundamentally towards, is preventing those things from interfering with the organization and protecting the members and the participants in the organization. And my guess is that most organizations haven't yet fully realized that. They see the safe sport policies more as a reporting obligation or a box ticking exercise to try to get themselves up to speed and qualified. They don't see it as the ongoing responsibility for supervision and interaction on an ongoing basis with the participants and the state of play, the field of play, as it plays out. Similarly, on the financial side, the board of directors should always be as focused as possible on the state of play of an organization's finance through the year, and not just wait until the end of the year to find out where things sit. So if you have a staff member, you're lucky, because a lot of organizations can't even afford staff and it's all volunteer done or whatever. But to the greatest extent possible, the board should, on an ongoing basis, be asking about deviations from the budget, expenditures, potential concerns about misuse of funds, those types of things. And even if it's just a standing question at every board meeting, when you get your finance people in, or your treasurer who you've selected as being responsible, make sure that you're asking the right questions. Make sure that you're trying to identify what the financial position of the organization is. Make sure you're asking whether or not there are appropriate checks and balances in place for signing authorities on documents. Make sure that if there are any expenditures over a certain level, say $20,000, that those are brought to the next board meeting, if not in advance, where they may require approval based upon the financial policy you have. Make sure you have an appropriate financial policy in place so that the board has set a standard such that no one can spend more than X dollars without board approval. Those types of things. You want to be responsible stewards of the money, because fundamentally, as a not-for-profit, it's not your money, it's the community's money. Because at the end of the day, your bylaws, by law, are required to stipulate what happens to your money when your organization winds up. And that money needs to go back to another not-for-profit purpose. It's not like you guys can set up a local soccer organization and build up a wealth of money and then distribute the money all to the membership. Those days of not-for-profit golf corporations, where you had a bunch of golfers who got together, formed a golf club, and then ended up with multi-million-dollar shares in wonderful real estate, those days are over. The money goes back to the community. You as organizations are just stewards of the community's money. So I've been rambling for about 40 minutes here. Fundamentally, your organizations exist as a creature of law that required at the time it was established to have a set of bylaws. The bylaws are the rule book for how the organization operates, and they set out the terms of the contract between the members and the organization. The members may or may not all be voting. You have the ability as an organization to establish who should vote and have a right in the direction of the organization and who could be a non-voting member or a participant. The governance structure is entirely up to you. We strongly advise against having children as voting members and that you adopt appropriate representation. Should you have membership where you could be a member under the age of 18, ensure that parents exercise voting rights on their behalf. Members do limited things. Members often think that they are holders of the ability to do everything in an organization. Members really have limited rights. They they receive the financials, they appoint the auditors to ensure that they control who has oversight of the financials, but they don't approve the financials. They just receive the financials, and they elect directors, and then the directors run the show. So your bylaws then also set out the rules of play as to who's qualified to be a director. We recommend, to the greatest extent possible, the concept of independence be adopted to ensure that conflicts of interest are at a minimum. We like to provide as much flexibility to the board of directors in the bylaws as possible to ensure that directors have an ability to, outside of the bylaws, adopt policies with respect to complaint and discipline procedure, conflict of interest, confidentiality, any type of policy or conduct that the board of directors believes should be addressed outside of the bylaws. Leave that power with the directors rather than force an organization to come together and have to go through the formal process of amending bylaws to do that. Let the policies live outside of the bylaws. Streamline the bylaws so that the directors are empowered to do the right thing. And then we like to advise the directors to focus on proper administration and stewardship of the public interest, especially with respect to safe sport issues and financial issues. And that basket of core principles, that's good governance. Layered on top of that, transparency, fairness, and common sense. We encourage boards to be fully transparent about what they're doing. We encourage boards to ensure that the organization has a website where all of the policies are easily accessible, where the bylaws are easily accessible, so that everyone understands the rules of play and the obligations on a go-forward basis. We talked about the membership documents and ensuring that the membership documents, when people sign up on an annual basis, have the membership turning over on an annual basis. And as part of that annual membership, you are signing up to agree to the organization's policies, rules, procedures, bylaws, all of the governance materials at the same time. An organization that is transparent like that, where everything can be easily seen, where the bylaws are written in non-legalese and the policies are clear, written in non-legalese and easily accessible, that's an organization that reflects good corporate governance and makes it easier for membership and participants to understand exactly what their obligations are. And what that does is when something goes wrong, when somebody doesn't act as they should, it makes it easier for the organization to step in and say, that isn't acceptable because it was a violation of something you were well aware of, and you were thus accordingly required to do X, Y, and Z pursuant to our discipline process. And with that, that's kind of the broad overview from our perspective of what good governance means. Do you guys have any questions?
Thanks, Greg, for your breakdown. I do have a couple questions. If anyone else has, feel free to chime in. But the first one I have is, you touched on a director's fiduciary duty kind of earlier in the call. Can you just be a little bit more specific about the duty of a director and the liability that carries, and why it's important as a director then to ensure that these things like financial controls and correct policies and procedures are in place?
Yeah, it's a very good question. Directors are responsible to act in the best interest of the organization. And where a director fails to act as a reasonable person in that director's position would act, that director is potentially personally liable for failure that results. Now, one of the reasons people tend not to want to serve on boards is they fear personal liability. The personal liability is a bit overstated because at law, specifically, a director can only be held personally liable for egregious behavior. Like it would be something that constituted egregious illegal behavior, except for very limited circumstance, which relates to an organization's unpaid wages and unpaid taxes. And so, as a director, when I talk about the requirement to stay up on top of where an organization is throughout the year with its financial position, directors should always be understanding where the organization is at in paying any tax, but that's not really an issue for a not-for-profit. Um, but more importantly, unpaid wages and any required contributions on behalf of any employees that the organization has. So it's one of those concerns, Stephen, that it absolutely is there in terms of potential personal exposure, but it's not really something that rises to the level of materiality, other than that you are required as a director to act in the best interest of the organization. Now, having said that, what is the sanction for not acting in the best interest of the organization? Well, embarrassment, removal, that type of thing. The financial exposure isn't that large for a director of a not-for-profit.
Thank you. And just one thing I wanted to kind of highlight too when you were talking about financial controls is I think just at a bare minimum for any organization, whether it's through staff or directors, is that you have at least two people who have full access to your financial statements, your bank accounts, and if possible, have a second signing authority, so that any expenses that are being paid out are being signed off by two people. That's largely where you're going to get into the most trouble, is if you have one person who has kind of full autonomy to do whatever they will with your financials. That's really the biggest risk you're probably going to see from a financial perspective, and where you're going to see things like fraud potentially occur. So that'd be a pretty big red flag if somebody like your treasurer isn't willing to have another signing officer or another person have access to those accounts. That'd be, from a process standpoint, my biggest suggestion.
That's a good point, Stephen. It's interesting because the two issues I talk about are safe sport and financial impropriety. And so the same concept applies to both. It's the rule of two. We talk about the rule of two in safe sport, right? You never leave a kid alone with one. Well, it's the same thing. You never leave a dollar bill alone with one. You don't. It's the rule of two.
Mm-hmm. And then last one, just because this is something I get, I guess, as a question a lot, and it's more surrounding the specifics of the AGM. So who is required to be invited, and then the posting of minutes, collection of minutes, the necessity to post those publicly afterwards.
So it's interesting, and this gets back to the different types of membership structures that an organization can have. Every member is entitled to attend an AGM, whether or not the member is a voting member. If you have a split structure where you have some voting members and some non-voting members, doesn't matter. Every member is entitled to the rights of membership. It just may be that some members don't have the right to vote. The board can invite anyone else the board deems appropriate, but fundamentally, any member can attend. At law, minutes of members' meetings are to be publicly available to the members. Minutes of directors' meetings are not, unless the bylaws specify otherwise. And the concept there is that directors, even though they are representatives of the members between meetings of the members, directors are charged with a specific obligation to run the affairs of the organization between meetings. And what the legal concept at play here is, we want to make sure that directors have an ability to discuss freely and not worried that positions they take at the board level would ever be recorded in a way that would be embarrassing or reflective of decision making to the member. That you don't want people not saying what they think at the level of a director's meeting. So directors' minutes are not usually made publicly available. Some organizations, I shouldn't say that, a number of organizations in their bylaws will set out that directors' minutes can be made available. But best governing practice is to keep the directors' minutes away from directors so that only decisions of the directors are made public. On the website, members' minutes should be made available, and the financial statements have to be made available to members in advance of the AGM so that the members can show up informed to ask questions when they receive the financials at the AGM. It's interesting with respect to posting them on the website. There are two schools of thought there. The Canadian Sport Governance Code requires NSOs to now post financial statements in the interests of full disclosure and the issues that have gone on at the national level. There's no best practices with respect to local organizations posting their financials. Transparency would say absolutely you should post your financials. What harm could there be? Question is are there competitive issues? Is there a competitive disadvantage to organizations who post them as against those who don't? Don't know, don't believe so. I'm a big advocate in favor of full disclosure and transparency, but there's no right answer on that issue.
Yeah, and for us in Saskatchewan, the Non-for-Profit Act does state that you have to circulate your financials 21 days in advance of your AGM. Yep. There's a caveat to that because there are some organizations that, based on their size, don't have to do a full audited financial statements. Yep. But for the most part, if you're large enough that you have to circulate them in advance.
And that's another thing to remind everyone of. Depending upon the size of your organization, you have different obligations with respect to how you treat your financials. If you have less than $100,000 in annual revenues, you can potentially dispose of the obligation to have financial statements in the first place if you have an extraordinary resolution of the members. If you're over $500,000, you absolutely have to have fully audited financial statements. And in between, you can have a review statement done. Again, though, just because those are the rules doesn't mean that's what you should do. We highly recommend that wherever possible, directors engage an independent auditor to conduct an audit if possible. And if you fall into that lower range where a financial review is possible, consider getting an audit anyway, because it's simple protection for the directors to show that they're exercising proper stewardship of the public money to get the highest review possible, provided you can afford it.
Does anyone else have any questions? If not, then I'd just like to thank Greg for his time. Appreciate your insight on this, and I think it's valuable for all of our members. I know I get questions about these types of things all the time, and this was a very kind of broad breakdown of this. You could go into governance for hours and hours if you wanted to get into the details, but this is a good starting point. And from our perspective, we're willing to support membership whenever. If you have further questions, if we can answer, we will. And if not, then we can look to experts like Greg in sport law to help us get those answers for you.
Yeah, and Stephen, that's I think a wonderful way to end it. This is just a starting point, right? Because every situation will require a different solution, because no two organizations are the same. No two organizations face the same community dynamic, the same potential issue on the board, the same issues with respect to discipline in the community and with respect to the membership. So a fundamental tenet that I like to encourage in organizations: pay attention to the rules, ask Steve for help, and try to build as much flexibility into your governance documents as possible while posting them so that the board has the ability to step in and do the right thing as the board sees fit.